Hello, I'm Lucy Bluck and I work in the private client team at Kingsley Napley. Welcome to our video guide for beneficiaries. A beneficiary is a person named in a will as someone who's to benefit from the estate, which just means everything owned by a person who's died. It's also possible to benefit from an estate under the intestacy rules, which sets out the order of priority for those who will inherit where a person dies without leaving a will. For more information, please watch my colleague Joseph Austin's video guide to intestacy. As a beneficiary, the chances are that you may well be grieving for the loss of a loved one, as well as trying to get your head around what can be the very complex process of actually administering the estate. In this video, I'll address some of the common queries beneficiaries may have about their legal rights, the expected timescales involved, and the administration process as a whole. As a beneficiary, you only have legal rights over your share of the inheritance once the personal representatives, executors or administrators, have ascertained the estate and established there is sufficient net value to pay your legacy. If there is insufficient net value, there are abatement rules setting out which legacies take priority and how the remainder is shared out. However, beneficiaries do have a right to information before this point, so should be kept up to date with the administration of the estate by the executor, the person or persons in charge of administering an estate. The executor will deal with gathering information about the estate, reporting to HM Revenue and Customs in relation to inheritance tax or IHT, and applying for the grant of probate, which is the document which confirms the legal authority given to the executor to act in the administration of a deceased person's estate. For more information, please watch my colleague Deepa Shah's video guide on executor duties. The executor should ideally agree with you at the outset how often they'll give you an update and stick to this throughout the entire administration process. Once a grant of probate has been issued and the administration is underway, the executor must keep accounts of the estate and be ready to show you these if you ask for them. Beneficiaries also often want to know whether they'll need to pay anything as part of the administration process. Normally they don't need to, but this will depend on the particular circumstances. Another common question beneficiaries want answered is how long it will take to receive their share of the estate. Unfortunately, there's no straightforward answer to this, and it depends on the circumstances. Generally speaking, the main stages of an estate administration are information gathering, reporting to HMRC in respect of IHT, applying for the grant of probate, and then distributing the estate once the grant of probate has been obtained. It is currently taking up to 16 weeks for grants to be issued, and where a full inheritance tax account is due, you have to wait 20 working days from when the IHT return is submitted before applying for the grant. A beneficiary who is left a gift of a fixed sum of cash, called a pecuniary legacy, or a specific item, a specific legacy, may not have to wait as long to be paid as a beneficiary who is receiving a share of the overall estate, called a residuary beneficiary. Again, this will depend on the particular circumstances. So that was a brief overview of the issues for beneficiaries and the key questions they may want answered. We have further resources and helpful guides on our website, but please also feel free to contact me or any other member of our team if you have any questions at all, and we would be very happy to help. Thank you for listening.